We still face kind of a long-term ingrained prejudice about women in the law, despite the fact that law schools are half women, if not more. But that first encounter usually presents an initial challenge as to whether you are the attorney present for the individual.
Welcome to The Defense Never Rests with Morgan and Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Hi everyone, it's Wendy Smith here, again with our podcast, The Defense Never Rests. Today we're going to be doing a podcast with regards to women in workers' compensation. And joining me today are some of my very esteemed colleagues in the Philadelphia Workers' Compensation Bar. We have two people joining us who are on the claimant or the employee side. So I'm going to introduce everyone. I have next to me Lisa Eldridge. She's here from Martin Law. Lisa, I'll let you introduce yourself.
I will. Thank you very much. And did you say esteemed or esteemed?
Esteemed.
Okay, thank you very much for the very kind introduction. Yes, my name is Lisa D. Eldridge. I'm with Martin Law in Philadelphia, Pennsylvania. Thank you.
And I also have Melissa Chandy here from Pond Lehocky.
Hi, Wendy. Thanks for having me. I'm a senior associate at Pond Lehocky.
And I also have Ashley Shilgan here, who is from my own firm, and I've worked with her for many years, even before she came here to Morgan and Akins.
Yes, good morning, or good afternoon, I should say.
So today we're going to talk about some of the challenges that we face, especially as women and minorities in this bar, with regards to how we handle clients, how we litigate cases, some of our approaches that we have with our strategy making, especially in settlements, and even the relationships we have with other counsel. So one of the things that we were talking before we started the podcast is, I know we are in court all the time, and we have, and in depositions. So we're always, on the go. Workers' compensation cases move very fast. So we were talking about some of the challenges that we face dealing with the fast pace of our practice. So Lisa, you've actually been on both sides of the fence.
That's true, I have.
Will you tell us which one you prefer better?
I can't say that I prefer one side over the other. I certainly must acknowledge that representing injured workers has been a godsend to my life and to my career. I feel I have been able to use more skills representing injured workers. You're not simply an attorney, you become a psychologist, a psychiatrist, a physician, a mother, a father. Whatever your client needs from you on that day, you provide. It's much more challenging, I believe, to be on the claimant side. I don't know whether Melissa will agree with me. We often do face some interesting encounters with our clients. I know I have been asked whether I am an attorney at that first session. I don't think that's odd for any of us around this table. We will, and we do. We still face kind of a long-term ingrained prejudice about women in the law, despite the fact that law schools are half women, if not more. But that first encounter usually presents an initial challenge as to whether you are the attorney present for the individual. Once you're over the hump with that, there's usually no issue.
Yeah, and I faced that, especially early on in my practice. I look young. Or I hope I look young.
You are young. You are young.
And when I started practicing, I know when I would go to court, and I'm there in my suit, and I have my trial bag with me, and I have all my files in the trial bag, and the first thing out of people's mouths when you enter the court, even from, other practitioners, judges, are you the claimant or are you the court reporter? I get that a lot, because when you're carrying the bag, they think you're carrying your stenographer equipment. So I'm used to that. First you're very taken back, but nowadays you just say I'm an attorney, who you are. I know, Melissa, you were saying you had an incident this morning.
I did. So it's funny because of those past experiences, I always introduce myself, who I'm with, who I'm covering for. So this morning I had a female client, Hispanic. We go through our entire prep, her case, what's going to happen next, and we're sitting waiting for her hearing to be called. And the other attorney walks into the room. It's a man. And she looks, I say, that's the other attorney who's here for your case. And she says, is that my attorney? Is he on my side?
After she just told you all about her life and her case.
Exactly. So I think sometimes it's the perception that the man is the attorney, like Lisa said earlier, and it's getting past that notion that as a woman we can't represent clients. So we discussed pretty much everything with her case, so I assured her she's fine, I'm her attorney, I'm on her side, and then we got through the hearing.
Do you feel that in practice we're treated differently than our male counterparts?
I don't find any difference amongst judges or amongst our colleagues, male and female. I do find some difference amongst clients. And again, it's usually the initial moment. It may extend beyond the first moment, but that's where I see the difference. I don't have any issues with anyone with whom I've practiced, against whom I've practiced, as far as understanding and acknowledging that I am a lawyer and have been for more than a few years now.
I think for me in the beginning there was a little bit of an issue with the male counterparts. I think it took a while, for them to recognize me, get used to me, and then earn their respect. I think in our practice we do have a lot of young attorneys that are fresh out of law school that come into this area of law, and I think it does take a lot of the older gentlemen that have been doing this for a long time. I think it does take them a little bit getting used to the newer attorneys, especially the females. But I think once you show your face, you interact with them on a daily basis, and they gain your respect. I have had since the first 6 months I've been doing this, I don't find any difficulties with male attorneys, male counterparts, and especially not judges. I don't find that at all.
Ashley, did you feel you were tested initially?
Absolutely.
Yeah.
Absolutely.
Yeah, and I think we've all gone through the test.
Absolutely. You're the new person. You're not familiar with the lingo. I mean, I do workers' compensation in 3 different jurisdictions, so not just Pennsylvania, New Jersey, and New York, but it's a whole new bar. I mean, I've known you guys forever, I feel, and then you go into a different jurisdiction and you're the new kid on the block again. But again, it's about, establishing who you are, your presence, letting them know who that they've seen your face, they know what you're capable for. You always got that from the judges. I remember in the beginning, I know you're pitch hitting. I think that was like the thing that they used to say, for so-and-so, but you still are expected to know your case when you go up before the judge and know the issues.
I agree with you. I think the biggest mistake that we can make when we cover, and Melissa, the word cover, is if we are not prepared. And I think we're disrespectful to the client, no matter the side. We're disrespectful to the judge if we are not prepared. So my whole practice has been emphasized, or at least the emphasis has been on preparation. And that starts by arriving on time for court, making sure that I'm there first to meet clients, knowing the case, and I'm sure you all have the same system we do. We have notes. I read all the notes, not just the medical records, not just the bureau documents, but I read all the notes concerning the case, because that gives me background, or gives us background on what to expect, not just that particular session before the judge, whether it's a continuance or testimony, but maybe how the client's feeling leading up to the hearing, the case so far, and I know you're going to get into strategy and things like that and how you relate to your opponent, but I think the emphasis, and I'm sure you tell younger attorneys, you have to go to court prepared.
Absolutely. And it also I also emphasize this with attorneys on any side. You say you're covering or you're pitch hitting or whatever, you go in. We write status reports. We are obligated, I mean, that is the number one thing that you tell a client. You do the initial evaluation. In your status report, I don't want to hear you say or see what you write, that you showed up for the hearing and then there's going to be another hearing in 5 weeks and that's it, and we need to schedule medical. There has to be some thought behind this. What is your ultimate goal? What are you trying to achieve? You have to let the client know what your expectations are for the case. And from our end, it has to deal with money and reserves. If this case is not going to settle, they have to put aside reserves for your litigation costs and things like that. So I always try from the start, when you teach attorneys on how to practice, that's one of the things that you have to take into consideration when you're going there. You're not just putting a suit on. You're not just showing up in court and saying, "Hi, my name is Ashley. I do this. This is what here's my evidence for today," and I go home. That's, there's more to that. That's what we're paid to do. We're attorneys. We're here to counsel.
I was always very impressed with you guys, though, because, when we walk in, we typically only have 1, maybe 2 at the most of cases that we're handling in one day, and you guys could have
Multiple.
And multiple courtrooms, multiple different personalities. And I've always been impressed in one, how you prepare and how you keep it organized.
So I appreciate that. And I think what I learned is to never say I'm covering or I'm here for someone else. It's my file when I'm in that courtroom and before that judge, because I've seen younger attorneys make that mistake, and the judges don't want to hear you're covering because that's an excuse for not knowing the file. So when I go in, as Lisa said, I review it. There may be 10, 15 hearings that day, but I need to know that case. And I will never say I'm covering for someone as an excuse for not knowing. You have to take ownership of those mistakes.
Absolutely. It's your file, it's your client, it's your issues that you're dealing with on that basis, on that day. And one of the important points you brought up, Wendy, is about the status report. You don't want to just simply put dates and times and the outcome. You need to have some meat in that status report, because the status report is written for you, by you, but it's also for everyone else in your firm who may pick up that file at a later point to understand how the case is progressing, what happened on that particular day, but what will happen based upon what you observed and dealt with at the particular hearing or deposition or client meeting or settlement conference, any of those events that we deal with repeatedly, day to day, 5 days a week.
And that kind of segues into, what I was thinking we would talk about our approaches to our practice and how we litigate cases and strategy. You guys deal with a different set of clientele. What are some things that you find very valuable when you are preparing for cases and you're in the middle of litigation and then you're taking either just settlement or decision?
One of the points I raise with clients, whether it's a settlement conference or a hearing, is to explain it's not television. It's not Judge Judy or Judge Joseph or any of the judges. It's not how to commit a murder. It's workers' comp. It's real world. This is what the case is worth. This is how it's valued. There's no pain and suffering. There's no loss of consortium. Your expectations have to be lowered a little bit.
Do you tell them that there's an end game to this, like that it doesn't go on forever?
Absolutely.
So we'll go over the pros and cons. So workers' compensation technically can go on for your lifetime.
Right. Yes.
But that lifetime can involve surveillance, it can involve hearings, it can involve a lot of back and forth with the insurance company and judges. So,
a lot of intrusion.
Exactly. And so expectations are important, because also sometimes clients will say, my neighbor got $3 million for his case. And that's just not going to happen. And you have to tell your client what how workers' compensation benefits are paid, how settlement values are reached, and what is the norm in workers' compensation. So reining in the expectations and going over what the end game is really important to make sure the client's expectations are reasonable.
I was going to say, I was wondering if you get a lot of that, I know so-and-so, well, they got this, I think I'm entitled to this. And do you have that conversation at the onset, at the initial consultation, or is that a work in progress, I guess you should say?
It's a work in progress, but generally it comes up immediately, because the individual may say, well, my neighbor said that he knows a person who received, so right away you stop, you take a breath, you pause, and say, let's start all over again. This is how workers' compensation works, okay? Your neighbor's case, was it a workers' compensation case? No. So let's rethink this. If it's not workers' compensation, then it's not really relevant. But you don't belittle the person, because this is what they see on a regular basis on TV, movies. It's what they read in books. You just bring them back to workers' comp reality, and you explain everything again, and then everyone is on the same page, and that's where we all need to be. I also absolutely report to the person who's going to be there on behalf of the employer, what he or she is like, what he or she is going to ask, that you ask questions for the most part to which you know answers. And I always tell clients to be honest. Don't lie. Please don't lie, because a lie is so easy to expose. It's so easy to expose, no matter the subject of the lie.
Right.
Yeah, I mean, we have an obligation, obviously.
Sure.
When I get a file in, it could be they've accepted the injury or they haven't accepted the injury. And one of the things that people, my clients especially, want to know, they want a budget. And they want to look at the litigation. And often it's very hard, especially people who haven't been in the industry for a long time. When you do an initial evaluation, you don't just evaluate the employee themselves. Sometimes I know the attorney could be difficult. They're going to drag this out. So
The judge.
Especially, people want to know, what do you think of the judge that's handling it? Are they pro-employer? Are they pro-employee? Do they come in the middle? Because for them, again, they're looking at reserves, how they're going to value the case, how much they're going to pay you. And sometimes that becomes a sticking point, because they might say, well, I've put X amount of dollars on this file, and we're now at this point, like, we want to settle the case, and we want to settle it for this amount, and that's all we're going to give you. But then, we're trying to mediate or settle a case, and now you might have a client that thinks that their case is worth this amount. And how you get to the middle point, that's obviously our issue that we have to deal with at mediation. But I think it starts, this is why I wanted to have this conversation about how you counsel your clients.
So I guess it's that conversation and looking at all aspects. So the medical, the severity of the injury, what's going on in their life. You want to get a real understanding of where they are and where the case is heading. So things like who the judge is, what the outcome may be, what the risks are, and why it might be in their best interest to settle. But a negotiation is a back and forth. So sometimes we'll hear from defense attorneys that it's an unreasonable demand. But give us an offer, and we'll go back and forth. And that's how we get to that number. So sometimes it's explaining to the client that maybe the mediation day we're not going to settle. But we're going to follow up, and we're going to see if we get to that number that makes everyone happy. So it's, I guess, advising your clients along the way as to what's going on to make sure that everyone is on the same page.
Do you find that when you give your clients a specific number at the outset, is that something that they hold on to and it sticks in the back of their mind and it's hard for them to come off that number?
Yes, that happens often. You relate to the client what your opening demand is, and they love it. And they go, well, we're not moving from that, right? I said, well, part of the negotiation is both sides do move. And the object is to meet at a number that dissatisfies both parties. Reasonably dissatisfied. Okay, not outrageously dissatisfied. So yeah, there is some work involved if your client is set on a particular resolution figure. And then there are times where you may tell your client, no, I don't want you to settle your case because you're not prepared to move on. You haven't done anything in your life to change. You haven't set goals as to finding another job. You're not ready to settle. So that's kind of a tough thing to say too to the client, is that you're not ready to settle.
Okay.
And I try not to permit the clients to undersell their cases and settle for money that is not going to get them past this bad patch in his or her life. But yeah, there are points where you do have to deal with a client who sets an expectation that is a little too high. So you have to work with the client, put aside the case maybe for a bit, express to the client how the litigation has progressed. Maybe the doctor didn't testify so well. Maybe there were some issues. Maybe there was some surveillance done that's pretty convincing. So you bring I always err on the side of being very honest with our clients so that they know what's going on in the litigation.
What about communication barriers? We were talking about, I've said to Melissa earlier, I said I have a case actually with your firm where I have a hearing impaired person. Well, that's your client, and I was taken back because I thought, okay, well, I've never had that in all the years I've practiced. I've had multiple languages, and now I'm dealing with somebody who's hearing impaired. So first thought is, well, when we take the testimony, we need somebody who can do sign language. Well, we find out that the person does not know sign language. They weren't born deaf. They didn't become deaf until later in life. And they also have a little bit of a hard time reading lips. So one of the challenges that I had, we had to have the judge come in to the deposition because normally your clients testify live either at the beginning or the end of a case. But at this point, because of the language barrier, I had the judge come in for the deposition. So we don't have to bring her back because we actually had to get a special translation company to type out all of the questions for the person to respond because you want it taken down accurately.
So communication, I guess, in depositions, we would have an interpreter or translator there. But there are times when the dialect is off or you realize there's issues in interpretation. But you have to make sure that the client, what they're saying is being translated accurately. So, for example, I've had there was a client where you could tell they're struggling with their answers during a deposition, and it's because something's off with the interpreter. So it's making sure that they tell me that, no, I'm not comfortable with what the person is translating, because most people have an understanding of English. It's just that they're more comfortable sometimes speaking in their native tongue. So communication is very important in getting that across to the client.
In your defense work, do you object to an instance where there's no interpreter available? It's an odd dialect. Do you object to a family member acting as the interpreter?
I actually had that situation in Bristol, and we had this was slightly different though, because it was a CNR. It was a settlement hearing, and his daughter, the claimant's daughter, ended up actually translating because we couldn't find anybody. And I felt comfortable enough with that. If it was testimony, probably not, given the fact that it was a settlement hearing, and I know that an interpreter had gone through the paperwork with his attorney prior to. I felt comfortable with that. I think with testimony, probably not.
Yeah, generally we find that a family member is okay for a compromise and release agreement because everybody at that point is kind of on the same page. We've settled the case, we want to get it through. But testimonial evidence, there could be, certainly from the defense standpoint, you want to make sure that the testimony is not weighted in favor of the claimant.
Right.
Yep.
And sometimes it's frustrating for our clients when we show up to a hearing with the wrong interpreter and they say, my daughter is here, my husband's here to interpret, but we can't proceed for that very reason.
Right.
So it's frustrating for them to have to come back to have everything scheduled properly.
But we do explain that you just can't move forward unless you have a court-appointed interpreter for a hearing before the judge.
Right.
That involves issues that about which the parties disagree.
Your offices must have multiple bilingual employees.
We have
Yeah.
employees on staff. We also, for depositions though, with the court reporting companies, they usually arrange that interpreter, and we also rely on family members as well to come to client meetings to help with the interpretation. So that helps.
I think that's a good point, Ashley, that you've raised about language. This isn't an English-only practice. We face so many different languages now. The employers hire people from around the world, and just because one person is from one of the African countries doesn't mean he or she speaks the same language as co-workers or even the interpreter. So it's a multifaceted case in so many ways. It's a real world. I keep saying real world, but it is. We deal with all types of people. I
think one of the interesting things we were talking about before we jumped on this podcast was not just the languages that we were talking about, but I forget which one had the experience with the person who was Asian Indian, and the interpreter wouldn't interpret the testimony
because they were from a different caste. I think that was your colleague referencing that situation.
Yeah, because there was an instance where the interpreter, because of the economic status, wouldn't take down the person, wouldn't interpret the person, not because they didn't understand the language, and at that point you have to get another interpreter, which costs more money, and I'm sure that is an insult to your client, embarrassing and things like that.
So it's back to me and Melissa soothing egos and soothing feelings, and that's what we do quite a bit. We have to do a lot of soothing. And not in a patronizing way, but in a way that the person can understand that this is not personal. There's no insult intended, but we'll get it done. You'll get the right interpreter. You'll have your moment before the judge.
I used to joke around with people on the claimant side. For attorneys, I said, do you ever give out your cell phone number to your clients? And they said, I think everybody said no. I don't think I've ever had anyone say yes.
No.
It's a no. Yeah. I think certain attorneys may give their number out. Myself personally, I've never given it out. So it's
I think, Melissa, given the sizes of our firms, we don't give out cell phone numbers now. Individual attorneys may give out their cell phone number.
And we have software where I can call from my phone and my office number shows up, which is helpful because then it's private and I'm not going to get a call back. Not, just for privacy. That's
Absolutely. No, and I know it's for a lot of it has to do with safety reasons. And I brought that issue up at a former firm of mine where, nowadays it's on my signature line. It's an automatic thing that comes up on my email, and I have my cell phone number on there that people can call. And I do, especially for my clients, I do say I'm available if you can't sleep at night and you really need someone to talk to, you can call me, No one has taken me up on that, thank God. But anyway, it's just one of those things that, I joke around, like, would you give out your personal info, like your cell phone number to a client?
I'm going to ask Ashley and Wendy. I did defense work for years. Is the timesheet still the most important daily activity you complete?
Yes.
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 It's not necessarily a sheet anymore. It's all computerized. But,
I gave away my age.
But yes, yes, that is the most important.
No, I used to use a triplicate form, and I would write down the time.
I'm sure that's something you don't miss.
No, I don't miss timesheets. Thank you.
You've never had that
Never
luxury,
had the
no?
honor.
No.
It's something that is necessary in our industry, but and I guess, at this point in my life, it's so ingrained. Yeah. And I'll say this, you do this all the time, it's just like point 1, point 2, you just get used to it. But the worst is when I'm home on the weekend. It's not that I clock my time of what I'm doing, but you're very conscious, like, I have enough time to go to the gym. Now I have enough time to go get groceries, do laundry, that kind of thing like that. And it all becomes sort of categorized because of this whole timing system.
It's actually funny. My husband does that all the time. I'll be talking to somebody. He'll be like, "That's a point 2. She's going to charge you." Like he has it. He even jokes with me now because everything is in those point 1 increments. But yeah.
But it's back to the issue of preparation. Part of the preparation is completing the timesheets, getting the timesheets in so that your firms get paid appropriately. I know it's very important. It was emphasized where I used to work, and it should be emphasized because it's an important aspect of your life. And I'm sure when you meet with a new prospective attorney, you explain to him or her, you got to get your timesheets in.
Yep. I find that's something that's very hard for new attorneys as well. New and paralegals and
Sure.
staff members that do it. I said one of the hardest things about your job is actually the time, is keeping your time.
Yeah.
So talk about relationships with other counsel. Now, I've known you guys for a very long time, and obviously I invite you on here for the podcast, but have you dealt with difficult situations, and not just difficult counsel, but difficult counsel or different situations where you really need the help of your other counsel, of the other side's counsel defense?
Or what do you mean exactly?
I just think about things like this, like maybe I've been asked, and it's a rare occasion, but sometimes I've asked me to come in and join you, like at a mediation. Obviously, I don't go meet with your client, we have ethics. I don't do ex parte communication, but at mediation, sometimes, I've had to explain some things, to you and your client or whatever. We've talked, I talked to you about it first before joining your client, but sometimes it's helpful, to understand where we are with the case. Maybe it's a medical issue or payment, how after we settle a case, how are they going to get paid? Those kinds of issues.
I have absolutely no problem introducing any of our clients to defense counsel. In fact, I think that's important that they see the defense counsel. In mediation, I invite the defense counsel in and explain that Ms. Smith is here on behalf of the employer and the carrier, and Ms. Smith's position is this. And mediation is a little more relaxed, right?
Yes.
Nothing's recorded, nothing's repeated. So you can explain to our client what you have in mind, and we may get there, or not your number, but our number is better, that type of thing.
Do you think it makes your client feel a little more comfortable knowing that, one, we are human. We are. They don't see the big bad wolf on the other side because maybe that's the picture that they've had in their mind of this opposing attorney.
Certainly, it is the picture that they have in their mind, and sometimes you have to be careful with it though, because you don't want to become, you know Miss Smith, and you run with Miss Smith, or you have lunch with Miss Smith, and you don't want that situation to the point where the client feels that you're more on Miss Smith's side than on the client's side. So it's kind of delicate, but I think we all do it really well. I explain to the client, Miss Smith is here for the carrier and the employer. She has her position. I'm here for you. We are going to talk cordially. We're going to be polite, but we do differ.
Yeah, I've only had a few occasions where I've had a difficult opponent, and in fact, I've had times where it's actually the attorney that's more of a hindrance than the claimant. Right. I've had sometimes the claimants looking at me like, what do I do? Which is a shame, but it does, that has happened in practice, and I'm always very careful, that's your client. Regardless of how this is going down, I'm always trying to say, we're all in the same bar. And that's one of the things that I like about the Philadelphia Bar Association, that we are very collegiate.
I was just going to say that, because I don't know about the two of you. I know Wendy and I do practice other areas of law other than workers' compensation as well. I think you guys are solely limited to workers' compensation, yes. Correct? I find that the camaraderie and I think we are just so much more cordial with one another in this area of law. I know that's one of the main reasons that attracted me to doing workers' compensation. I find that everyone's, for the most part, there are a few stragglers. Everyone's very respectful of one another. We have an open line of communication. I think that's very nice, especially as females walking in there. I think we have a great female presence, both on the bench and as attorneys, and I think that's always nice. And I think we're very supportive of one another. I find that to be a very special part of workers' compensation that I don't see in other areas. I
would agree, because I think we can make our objections and we can make our arguments, and then the deposition ends and we're back to being cordial. We're friends, we're colleagues. But in the moment, we are able to do that without getting personal, without getting rude, without crossing a line, which is the nice thing about workers' comp in this small bar, that we do know each other.
Well, it's back to the point we made at the beginning, that we're so busy all the time, you can't take your hang-ups to the next event, because you're going to mess up the next event if you're still mad at whomever from the hearing outcome. You have to compartmentalize, I guess that's the word, put it in a compartment and handle each event individually. So you do not take anger with you. You shouldn't be angry when you approach these cases. I mean, you can be aggressive. You want to handle your cases the best that you can for your clients, but you shouldn't be mad. And the worst event I ever had was years ago. It was an attorney who didn't handle compensation. We had a deposition with a doctor in the lower Northeast, and he just came in angry, and he started yelling and screaming. And I said, we're stopping. I'm calling the judge, because this shouldn't be like this. Yeah. It shouldn't be.
No, and I've had it where, I've actually, I was saying sometimes I've actually had to look to you guys, at a deposition once. I had the doctor out of control, and sometimes that's beyond anyone's control at that. But no, it is really glad that we have that camaraderie. And also, I wanted to bring back to the beginning part, when we evaluate a case for our clients, when we say we know the attorney, I know Lisa for many years. She is, she's handled workers' compensation on both sides of the fence. She knows her stuff. She's an excellent adversary. You want your clients to know that.
Absolutely.
Because, again, you go back to some of the people that you've dealt with who are not that cordial or are going to make your lives difficult. They don't want to settle just because of the fact that they don't want to settle, that kind of thing. So that's what I found challenging in my practice. Mm-hmm.
Absolutely.
Well, I want to thank everyone for joining me today here on our podcast, and thank you for coming out.
Thank you. Thank you for having us. Thank you.
Thank you.